are some of the biggest mistakes you see dads make, and what should they do or what can they do to avoid them?
As it relates to overcoming the presumption for an SPO?
Just in general, we're going through the process. What are some of the most common mistakes you see made, and what would you like dads to know so that they can avoid those mistakes?
So I'll break it down into two sectors, right? So with regards to child support, and we touched on this a little earlier, the biggest mistake that I see dads make is, making these payments, cash payments or payments that are not through the disbursement unit. That you're setting yourself up, and like I'm seeing a lot of the comments about, people who have paid and the monies that they've paid have been considered a gift. You're setting yourself up for that. I even advise my clients or even my male friends and family, it's probably best if she hasn't initiated a child support order, it's best to put your own stuff on child support. That's really the only way in Texas to avoid having to at some point be in some sort of arrears or owing back child support. I don't care how well you guys are getting along at the current moment. There's something bound to happen that is going to, disrupt that and make her mad, and you got to get a child support order against you, and now you're in arrears. And those arrears are hard to dig yourself out of that hole, man. It's so hard. And then the collection measures are so aggressive. And here in Texas, they will suspend your license. They will, suspend your professional license. They will, keep you from being able to travel out the country. All these different things that they do, man. It goes on your credit. All these things that they do. So the best way to avoid that, number one, no cash payments. Two, put yourself on child support. I don't care what kind of relationship y'all have. To avoid that in the end, it's best to do it that way. With regards to mistakes that I see a lot of dads make with regards to possession and access, and if they have the goal of wanting to be named as the custodial parent, not being more involved, right? If you know that you have hopes, just say if you're married or you guys are living together or whatever the case may be, you want to be as involved with that child's life or in that child's life and the daily processes as possible. Because if you ever stand before a judge in a situation like that, when you're asking for custody, you're asking to be named the primary conservator or the custodial parent, or you're asking for something more than a standard possession order, you want to be able to point to how you've been just as equally involved as the other parent, because now you have equal footing when you're standing before the judge, and no parent has a better claim or right than the other parent. But if all you've been is the dad that, just comes in the evening and kisses the child on the head and goes off and do your whatever you do, those things hurt you in the end. When it comes down to you trying to get more than an SPO or trying to be named as the primary conservator.
Yeah, I would put it pretty simply is doing something, not waiting. She's probably not coming back. She's probably not changing her mind. I saw someone in the comments. I don't necessarily know if it impacts, but I think probably 99 out of 100 attorneys would rather be the petitioner in a family law action, at least here in the state of California. You get to talk first. You get to set the narrative. You get to kind of go on the offensive, and California has some really bad domestic violence laws in family court, so you can kind of head some of those off. So doing something. If she says she wants to leave, she said she's filing for divorce, the next day being with an attorney, talking to him, talking through your options.
Yeah.
Number two is once you get that attorney, don't hide the bad facts from us.
Oh, God, no, please don't.
You got to tell us the good, the bad, and the ugly. And this is another topic that comes up every single week. The attorney-client privilege is probably the strongest privilege that exists. There are just certain things that, as attorneys, we will have to go to the grave with, not telling a single soul what we heard. And Cassandra's laughing because you hear it on a weekly basis. You hear something new. You're just looked at what has occurred. Tell us the bad facts, because if you tell us ahead of time, we'll usually be able to build a strategy around it.
Absolutely.
If it comes out at hearing, so you got to realize discovery isn't as in-depth as, say, some forms of civil litigation, employment law, business, things like that. If it comes out at hearing, it's very tough on the fly to fight that. Or if you tell us 3 days beforehand and we can't craft the argument around that, like we're just stuck with what we have.
Absolutely. I snicker for a couple of reasons. One, I just had this conversation with one of my clients today. But I tell my clients this all the time. There are two people in the world that you never lie to, and that's your doctor and your lawyer. Your lawyer, because they're, like you just said, we have that attorney-client privilege. So anything that you say is protected. Two, I want to know the bad facts. I want to hear them from you before, I'm in court, and I don't want to hear it on the stand. I don't want to hear it in a hearing. And I'm so adamant about that I make it clear to my clients, if I hear something on the stand that I should have heard from you first, you just lost your lawyer. You have just lost your lawyer.
Yeah. I sit down and I think the biggest thing I usually see is in that initial conversation, I use a one-page sheet in terms of starting to build out strategy. It's going to be, okay, what do you think the strengths of your case are? What do you think she thinks the strengths of your case are? What is she going to say? What are the worst 5 things she's going to say about you?
Yeah.
What are the worst 5 things you're going to say about her? You need to get those out.
You need to know.
All too often I see that a guy's not necessarily comfortable in that first, second, third meeting. And then we talk for a 5th or 6th time. And it's like, hey, so I have something to tell you. And we're hours into building out your strategy. And you just give us this game-changing bad fact or good fact. I see just as many guys that hide bad facts about themselves, withhold bad facts about their co-parent because they don't want to harm them.
We need to know it. We need to know it all because, again, it's not about judgment. Like this, I feel like a legal office is a judgment-free zone. It's all about us having the information that we need to develop the best strategy for our client. So if there's missing information, I'm not going to be able to prepare my case. I'm not going to be able to prepare my approach in a hearing as I would if I had known those facts. So it's a waste of everyone's time, money, energy, and effort for you not to be 100% transparent with your attorney.
Yeah, you as a client, the client owns the facts, and the attorney's job is to take those facts and craft the best strategy possible.
Absolutely.
So if you're giving us bad information, or you're not giving us complete information, that's like giving us half of a scouting report.
Absolutely.
It's not going to yield the best result. We're going to make bad decisions or not the best decisions because we're operating off of half the facts.
Absolutely.